BYJU'S Exam Prep IAS has been the gateway to your IAS prep. Our YouTube channel is going to get even better from 2023. Starting 2nd January, the Hindu newspaper analysis will be conducted live every day at 10 a.m. by your beloved faculties. Not only this, we have a whole new set of initiatives lined up for the new year to help you clear this prestigious exam. So subscribe to our YouTube channel now and give wings to your civil services dream.
Hello and welcome to Byjus Exam Prep IAS. Let's get started and look into the first article. The first article is about review petition. Let us try and understand what is this concept of review petition. We have one of the important articles in the Indian Constitution, which is Article 137. It says review of judgments or orders by the Supreme Court, subject to the provisions of any law made by Parliament or any rules made under Article 145. The Supreme Court shall have power to review any judgment pronounced or order made by it. What do we understand by review petition? As the very name denotes, it is reviewing the judgment of the Supreme Court. Let's assume for a moment we have a case in the Supreme Court of India. The Supreme Court of India has heard the arguments from both the parties and ultimately it goes about giving a judgment in favor of one of the parties. After giving the judgment, this becomes what is called as the judgment for the entire country. But then, can this particular judgment be reviewed once again? Yes, if there is a grave error or there is a new evidence that is discovered or there has been a significant error that the Supreme Court is able to discover, in that case, the Supreme Court can review its own decision. That is what is called as the review petition. So what happens in review petition? A judgment is already passed by the Supreme Court of India in favor of one of the parties. But because there is an error in the judgment, because it is also known that humans can also make mistakes as well, they can also have errors when it comes to their judgment as well. In order to look into its own errors and its own mistakes, what the Supreme Court can do is look into its own judgment or an order is what is called as review petition. So review petition literally means that the judiciary will re-examine that case, reconsider that case, and this is because of the universal acceptance of human fallibility. So what we have to consider is under Article 137, this is also regulated by any other law which is made by the Parliament, and at the same time the Supreme Court can also make rules under Article 145. So both these will be considered and ultimately review will be considered by the Supreme Court of India. So what is the rationale behind review petition? This is for the rectification of the error. This is to make sure the justice is delivered to the parties and ultimately to remove all the errors and the issues that are existing in its own judgment. We have the Supreme Court of India which accepts review petition under Article 137 of the Indian Constitution. So what is the procedure for the review petition? As per the Supreme Court Rules 2013, a review petition must be filed within 30 days from the judgment or order of which review is sought and must be placed before the same bench which had delivered the decision. In exceptional circumstances, if this 30 days mark is also breached, the Supreme Court can accept it if they are able to justify why they have filed the review petition. So basically, within 30 days, they have to file a review petition before the Supreme Court of India. But in exceptional circumstances, in those cases where they have discovered new facts or they have new evidence, in that case, in exceptional situation, the Supreme Court may also accept if it is beyond 30 days. The point to be noted is whenever the review petition is filed by the advocate, what exactly happens? There is no open court hearing. This is once again the discretion of the Supreme Court, but in most of the cases there will be no open court hearing, which means this particular petition will be filed by the advocate or one of the parties, and this particular case will be heard by judges individually. So this copy will be sent to individual judges. They need not have to come together as well, and if they are able to pinpoint that there is an error in the law or there has been a discovery of a new fact, this has to be notified in that review petition and ultimately should be sent to the judges. And also note, those judges who have given this judgment, it will be same judges or Let's say, for example, we have Judge A, Judge B, and Judge C who have heard this case. So it will be the same judges who will also review the petition, which is the review petition. So it is the same judges who will review this particular petition, and at the same time it will be sent to them individually, and they decide whether it has to be heard in open court or not. But in most of the cases, it will be within the closed room, and this will decide what are the fortunes of this particular case. As we told you, there is what is called as discovery of fact, or there is an error in the law. What do we mean by discovery of the fact? Let's say, for example, in a criminal case. In a criminal case, the Supreme Court of India, let's assume for a moment, has imposed death penalty for one of the persons. While all this was happening, the police officers might have got a new evidence saying that this particular person may not have committed that heinous offense. He was not even involved in that particular case, but instead it is his twin who committed that particular offense. So they have a new fact right now. So it is not this person who's committed, but it was his twin. But in this case, the Supreme Court has a new evidence in place, or there might also be an issue where the interpretation of the law may also have gone wrong as well. So if there is discovery of a new fact, or there is an error in the law, in both these cases the Supreme Court may review its judgment. In one of the landmark judgments of Eastern Book Company versus DB Modak, the Supreme Court declared that the review petition is liable to be dismissed on the grounds of delay itself. So the Supreme Court can also dismiss the review petition if it has taken too much of time for the review to be filed in the Supreme Court of India. So this is the procedure that is generally followed when it comes to the Supreme Court of India. Now, who can file a review petition? So there are two parties. The two parties can file for the review petition, and at the same time, if there is any other person who is aggrieved by this ruling, they can also seek the review as well. So parties who are affected, they can seek for the review petition, and if any other person who is also impacted by this decision, he can also file the review petition. So what are the grounds for the review? In 2013 ruling, the Supreme Court laid down three grounds for seeking a review of a verdict it has delivered: the discovery of new and important matter, or evidence which after the exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him. So he did not have this fact, he did not have this evidence, but he discovered after this judgment was made. In that case, please get this evidence, submit before the Supreme Court, is the first one. Second is a mistake or error apparent on the face of the record. Third is any other sufficient reason. In subsequent rulings, the court also specified that any sufficient reason means a reason that is analogous to the other two grounds. These are the grounds for review. Now the big question is, what is the difference between review and appeal? What happens in appeal? Let's say, for example, we have a trial court. The trial court has looked into this particular case. They have delivered a judgment. Now this person is not satisfied with the trial court judgment. So what does he do? He goes to the High Court of a relevant state. He files a case in the High Court, goes on an appeal, and the judgment is in favor of one of the parties. The party is yet not satisfied. So what does he do? It goes to the Supreme Court. So when we speak about appeal, what exactly happens? A person goes through a hierarchy of cases from trial court to High Court to the Supreme Court. That's how he keeps filing his cases. But when it comes to the review petition in the Supreme Court, what exactly happens? The same court will review its own decision because it feels that there is an apparent error when it comes to its judgment, which is what is called as review petition. So in review petition, it is reviewing it. But in appeal, what happens? There is hierarchy of courts which a party goes through. That is what is the major difference between the review petition as well as appeal. When hearing a review petition filed against its own order or judgment, but when it comes to appeal, there is a series of cases that goes from trial to High Court as well as the Supreme Court. Is this the last option for a party? No. We have something called as the curative petition. So it is the curative petition that a person can go through if review petition also does not work. So the review petition happens, then one of the party has got this judgment in his favor, so the other party can also go to what is called as the curative petition. So a curative petition may be entertained only after a review petition has been disposed of. What are the guidelines for the curative petition? When we look at the guidelines, the Supreme Court has held that curative petitions must be rare rather than regular and be entertained with circumspection. The ground stated in curative petition must be taken earlier in the review petition. A curative petition must be accompanied by a certification of a senior advocate pointing out substantial grounds for entertaining it. It must first be circulated to a bench of three senior most judges and the judges who pass the concerned judgment if available. Only when a majority of judges conclude that the matter needs hearing should it be listed as far as possible before the same bench as well. If at any state of consideration the curative petition the bench holds that the petition is without merit, exemplary cause may also be imposed on the petitioner as well. Now, as part of the assignment, you have to put on the comment section what are the recent cases where you have seen or encountered review petition filed in the Supreme Court of India or curative petition. What is this case law? Please put it on the comment section. So whenever you're writing your answers in your examination, you do require such case laws. The more the case laws, the better is the marks. So if you have encountered a review petition recently filed in the Supreme Court, which is this case, put it on the comment section. Same is to do with curative petition. Now let's look into the next article. This article says Prachanda sworn in as Nepal PM. Let us try and understand what is this article all about. There are about two articles in the Hindu. Let's take it together and understand as one single issue. What we have in this article is the election of a new Prime Minister in the country of Nepal. Pushpa Kamal Dahal Prachanda happened to be the new Prime Minister of Nepal. This happens to be the third time he is becoming the head of the government in the past 14 years since Nepal's monarchy was abolished, and before joining mainstream politics in 2006. He was also part of the Maoist movement in Nepal as well. Now we have President Bidya Devi Bhandari who was appointed Prachanda as the Prime Minister of Nepal as per Article 76 of the Nepal Constitution because he is now backed by as many as 169 of the total 275 members of the House of the Representatives in Nepal. Let us try and understand what is this article in greater detail and what could be the possible impact to India. When we speak about Nepalese general elections were held in the month of November 2022. The elections were held to elect as many as 275 members for the House of the Representatives. And after this, what we had is one of the political party which became a major political party and largest party with largest number of seats. But then they were not able to form the government. That is when coalition comes into picture. We have Sher Bahadur Deuba's Nepali Congress which had emerged as the single largest party. However, it fell short of the majority mark and therefore had to forge a coalition. The NC-led alliance comprised Prachanda CPN Maoist Centre, CPN Unified Socialist, Lokotantrik Samajwadi Party. It faced only CPN Unified Marxist-Leninist Coalition comprising Rashtriya Prajatantra Party and Janata Samajwadi Party. So the Nepali Congress coalition basically meant that they should have been ideally forming the government. Why? Because they had the largest number of seats on one side and at the same time they also had the coalition support of many major political parties as well. So who should have been ideally the Prime Minister? It should have been Sher Bahadur Deuba. However, in a last minute move, what we had is a change of politics and now what we have is Prachanda who has become the Prime Minister of Nepal. That is because there was shift in allegiance. Their coalition is not just an alliance of two communist parties, Prachanda's Communist Party of Nepal and Oli's Communist Party of Nepal have come together. Ideally, Prachanda should have supported Nepali Congress, but he switched sides and now he is supporting a new coalition. Because they have a new coalition in place, Prachanda has gone on to become the Prime Minister of Nepal. Ideally, if everything would have gone well, it would have been Sher Bahadur Deuba who would have become the Prime Minister of Nepal. But because the coalition allegiance shifted, we have Prachanda who is now become the Prime Minister of Nepal. A clutch of smaller parties with at least one being pro-monarchy are adding to UML's 78 seats and the Maoist center's 32. The other parties in the coalition are the brand new youth-centric Rashtriya Swatantra Party, which has no clear political ideology but won an impressive 20 seats, Nagarik Unmukhi Party, an outfit led by murder convict Resham Chaudhary, Janmat Party led by C.K. Rawat with its base in Eastern Teria, and as well as Janata Samajwadi Party. Why did this happen? That is because when you look at Nepali Congress, it was led by Sher Bahadur Deuba. He wanted to become the Prime Minister of Nepal, but then Prachanda also did request that he would want to become the Prime Minister. Since there was friction between these two leaders from two different major political parties, that is when Sher, that is Deuba, went on to say that he would not give Prime Ministership to Prachanda. This led to the friction, and Prachanda wanted to become the Prime Minister, and that is why he shifted his allegiance and he formed a new coalition, which ultimately led to the formation of the government, and he goes on to become the Prime Minister. Now, the big headache for India as of now is with respect to Prachanda Oli rise. We have two communist parties who have now come together. Because they have now come together, this is an headache for India. Now, India will have to carefully monitor all the developments that are taking place in Nepal and also focus what should be the future India's foreign policy towards Nepal. Why? That is because the surprise development of Prachanda becoming Nepal's Prime Minister is not good for India as well as Nepal relationship. Why? That is because Prachanda is seen as pro-China. So he in the past has always supported the Chinese political system, and he also supports the Communist Party as well. And at the same time, in the past, he also wanted to address key issues between India and Nepal, and he also wanted to revisit 1950 Friendship Treaty and also wanted to resolve Kalapani and Susta border disputes as well. So he feels that India has some issues with Nepal and all these issues will have to be addressed. He was also against these disputes while he was canvassing for his elections as well. Prachanda's main backer happens to be Oli. Oli also happens to be having a pro-China approach as well. So you have two political parties who have now come together and they have a pro-China stance. And during 2015 and 16, 2018 to 21, India's relationship with Nepal was not good because back then we had the Prime Minister in the form of Oli. But India-Nepal relationship had improved considerably in 2021 because of the presence of Sher Bahadur Deuba. Among the immediate concerns for Delhi happens to be the West Sethi hydropower project, which the Deuba government had awarded to India. So this Sethi hydropower project was awarded to India. During that period, Oli had opposed the decision as well. Now that they have formed the government, this could be an immediate issue between India as well as Nepal. So remember, what we have is an issue that can surface in the West Sethi hydropower project. And this also clearly points out the unstable conditions and the challenges ahead when it comes to the internal politics of Nepal. Ever since it has made its transition to a parliamentary democracy from 1990s and became a public in the year 2008, Nepal has seen as many as 33 governments in the past 32 years. For the Prachanda Oli coalition, the formation of the cabinet will also not be easy as well. Why? Because number of political parties have now come together. All of these people are now wanting to have a new berth in the cabinet as well, but they only have 25, which is the ceiling laid in the constitution. So how are they going to promote all these people as the cabinet members is what we have to wait and watch. So there is internal turmoil in terms of the politics, and India also needs to have a keen eye as to what is going to happen in India and Nepal, as we may have a government which is tilted towards China. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, what is Delhi High Court verdict on Rooh Afza trademark? What is the context? The Delhi High Court in the case of Hamdard National Foundation versus Sadar Laboratories Private Limited restrained Sadar Laboratories from manufacturing and selling beverages under the impugned trademark of Dil Afza. The court observed the trademark Rooh Afza is prima facie a strong mark requiring a high degree of protection as it has acquired immense goodwill. Let us try and understand what is this larger picture of trademark and what has the Delhi High Court said when it comes to this issue. First, we have to understand the meaning of trademark. What is the trademark? What is this symbol? This is a tick symbol. But what does this symbol stands for? Most of you would know that this stands for Nike symbol. So the minute you are able to see this, it has given you an imprint that this stands for Nike. And Nike also has a tagline as well. The tagline is let's do it. This is the trademark. So you have a symbol, you also have a tagline as well. The tagline is let's do it. Both these are what is called as the trademark. What is this symbol? This symbol is about Mercedes-Benz. So the minute I show you this symbol, you would be able to recollect and also reflect that this is the symbol of Mercedes-Benz. Now there is another symbol. This is the symbol of Pepsi. Pepsi happens to have a trademark in this form. This is the symbol of Pepsi. So this is a trademark, and a Dil Mange More is another tagline of Pepsi. So this happens to be a trademark. So what is a trademark? A trademark is nothing but a symbol. It can also be a sign as well. It can also have a tagline as well. That tagline or the symbol or a mark is what is called as the trademark. So for a business organization, for an entity running its business operations, if you are able to recollect and remember, that is what is called as a trademark. So a trademark can be a symbol. It is an indicator of the business organizations, and people would be able to identify a company or a manufacturing entity based on this symbol or the tagline. So what is the dispute right now with respect to Rooh Afza? Rooh Afza happens to be one of the drink that is manufactured by Hamdard National Foundation. So it is this company which is manufacturing Rooh Afza. There is another company called by Sadar Laboratories which is manufacturing another drink called as the Dil Afza. This is where the trademark issue has occurred. So the second company is making use of this word Afza. So the National Foundation feels that Afza has been taken illegally by Sadar Laboratories. It is a violation of trademark. How did the court come to the conclusion? The imputed trademark Dil Afza has a phonetic similarity with Rooh Afza. So Afza is also used by Sadar Laboratories. That is the first one. Secondly, if you recall from memory is triggered by the English meaning of words Rooh and Dil. The fact that the heart and soul is primarily used phrase. Third, the trade address of the impugned trademark, which consists of the bottle shape, design, placement of the house, colorfully busy design of the label are the material contributors to the commercial impression. So all this is adding to the value as well. That is, you have the bottle color, you also have the shape of it literally are similar. So the court goes on to conclude this judgment in favor of National Foundation, where it says yes, this is a violation of a trademark, and then it has imposed interim injunction. And finally, the value of the product was taken into the consideration as well, and ultimately it has come up with the interim injunction and gone in favor of Hamdard National Foundation. So what we have is Sadar Laboratories which would not be able to release its product in the market until this issue is sorted. So what is the importance of the trademark? When we speak about trademark, it is a unique marker of identity. So the minute you saw the symbol Nike symbol, you are able to understand that it belongs to Nike. So this is a unique marker of the identity. So trademarks are important because they serve as a unique marker of the identity. You will be able to recollect that this brand, this logo, this symbol belongs to so and so company. So if you're planning to buy a good or a product, just because there is that logo, you would just take that particular product. The second happens to be the mark of standard and quality. Trademark can also convey a certain standard and quality of the product that consumers can easily identify. So you have Puma symbol, you would for sure know that this particular product might be good. You have another, let's say Adidas, and then there are also copies of Adibas as well. So you would be able to know the difference between Adidas and Adibas, and you would know what would be the kind of quality that can be expected. Third is about protecting a reputation. Then trademark registration offers safeguarding the reputation of a company, that their product, that their quality would be good in the market, and ultimately whatever you get as a final product or a good, the market will be able to give you the best quality. So protecting the reputation of the company is another advantage of trademark. Finally, it will also provide consumer protection as well, that the product is of certain standard and quality to the wider consumer base. So these are the advantages of trademark. Now let's look into the next article. This article says researchers want BD rolling declared hazardous process. A group of researchers have urged the government to declare BD rolling a hazardous process and recommend alternative sources of livelihood to them. Why? That is because in India, 71.8 million adults smoke BD. The studies suggested around 87% of the workers reported symptoms such as pain in the back, shoulder, neck, knee, joints, spondylitis, tiredness, and body ache. Workers also had musculoskeletal, gastrointestinal, skin, cardiovascular, oral, and eye diseases as well. And the women workers had more miscarriages, abortions, lower fertility rate, higher uterine problems, and newborns of mothers involved in the work were at 1.9 times higher risk for low birth weight and 1.7 times at higher risk for smaller for gestational age. Because of all these issues, they want that this particular sector be declared as hazardous process, and ultimately if there is an option, these people should also be provided alternative sources of livelihood, says this article. It is this that we have to understand with respect to this article. Now let's look into the mains practice questions. The provision regarding review is an exception to the legal principle of status analyze. Pushpa Kamal Dahal Prachanda taking oath as Nepal's new Prime Minister is not encouraging for India-Nepal relations examine. So please write all your answers on the comment section, peer review, and do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.